particular case. So what we want to make sure is that our policies are not facially unlawful. What does facially unlawful mean? This means that it is a provision that is clearly unlawful on its face. A good example of that was, this was actually AMR, American Medical Response. Their policy for social media stated that employees could not talk about working conditions or wages, which is unlawful, facially unlawful, okay, which we just talked about, okay? This is against the law. Also, when you're talking about the act of formally proclaiming or declaring statutory or administrative law in order to discriminate, that's what promulgated for discriminatory reasons means. Okay, or if the policy is enforced in a discriminatory manner, okay? What does that mean? That means that there was some kind of, in this particular case, there was some kind of union activity, okay? And what they were saying is that it only came about when it was related to a union employee did they decide to change the policy. Therefore, they were enforcing it in a discriminatory manner because they were only talking about union employees and not non-union employees. So it had a discriminatory tone, okay? And then what I talked about earlier, it was overly broad and ambiguous, okay? So you just want to make sure. What's the difference between slander and a protected activity? Slander occurs when an untruth is told willingly, okay? An untruth is told willingly. Like I said, we don't know if they really did hire psychiatric patients or not. Okay? Now, if we knew for a fact that they did not, then that would be a slanderous situation. Okay? So we just need to make sure that we are careful with our social media policies and with our policies in general. Okay? Now, penalties for missed meal and rest periods. This is a case with UPS, United Parcel Service, versus the Superior Court appellate. And on February 16th of 2011, the Court of Appeal of California address the issue of whether an employer must make two separate payments to compensate employees for failure to provide a meal and a rest period. Okay, this has always been the case, actually. So the only difference is that the Labor Commissioner actually published their first opinion letter about this particular issue. What does that mean? So let's say, for instance, an employer, by no fault of their own or because, or by fault of their own, failed to provide an employee with a meal or a rest period. And let's say they worked 10-hour shift, okay? So they would have had 2 missed meal periods in that case, right? Because you have to provide for every 5 hours of work a minimum of 30 minutes of a meal period. So let's say that employee missed both. And just, because, let's say that employee didn't take their breaks either. So they missed both their breaks as well. So that would equate to how many penalties? 4. 4? Department of Labor says, no, it's actually only going to be 2. Okay, so 1 for each infraction, regardless of how many. So if it's a rest period penalty, it's just 1. If it's a meal period penalty, it's just 1. Again, I've been in front of the Labor Commissioner several times, and this has always been the case. The only difference with this particular issue is if they have written an opinion letter to substantiate that fact. Okay, so you would only be liable for 2 penalties per workday. I should add that in, per workday. Yes.
I have a question about the meal. I know that you provide the meal break, but not the meal itself.
Right, it's unpaid.
Let's say you work at a deli. Is it okay to charge your employees a $3 a day meal charge?
Like a meal stipend, or you're going to provide the meal, but they're going to pay the fee. How are you charging that employee? So it's on a daily basis, they come and they just pay their $3.
After 4 hours.
After 4 hours, but they're giving you cash, just like any other.
Now it comes out of check.
Oh. No.
You can't do that?
No. No. You cannot reduce the salary of an employee for any kind of debt that they might owe you. Your best bet would be, have them pay for it in cash or with a debit card, that kind of a thing. And the questions I get all the time, well, what if the employee agrees to it? You would actually have to calculate, and you couldn't calculate in that case because maybe they don't eat that day. You don't know how many times they're going to eat in that week.
They eat all day long.
Right under the policy, no eating.
Right, you have a policy that says you're not allowed to eat while you're on a shift.
But here's a point I just want to go a little further on this. Now, with your particular, and I don't mean to put you on the spot, but are you requiring them to eat your food while they're there at lunch?
No.
Okay.
But you're still charging.
Yeah.
Okay, you're just going to
If
charge
they're
them for the use of food.
Only,
Yeah, only if they're eating, which they do.
So then how do you, so what do you do? At the end of the week, you calculate how many meals they've eaten and then you take the
No,
deduction?
just a $3 flat fee, they can eat whenever, you know, for their breaks. They can even take it home.
Okay, but what I'm saying is, do they, so you're saying, okay, for every shift you work, we're gonna charge you $3 a day, and that $3 a day is coming out of your paycheck on a regular basis? Okay, now, there is a way you can do that, and I'm going to explain that. So let's say at the end of the week, you calculate how many times that employee ate. So let's say they worked 5 shifts, and they only ate 3 times, so that's $9, right? So then what you would say at the end of the week, I agree for my employer to deduct $9 out of my paycheck for, you know, food that whatever, how you want to word that. And then you would have that employee sign it, date it, and they can agree, but they would have to agree to it every
Every week?
pay period,
Every
every
week.
week.
So they couldn't
Yes.
just do it, I agree that $3 will be come out for each time I work after 4 hours.
No.
No.
It has to be for each, you have to specify when the meal was eaten, the date, and you have to get an agreement every single week that they agree to it.
What if
Without
I
that,
was-
there's no way around that.
What if I was on a special diet and I didn't eat your food?
Right.
You wouldn't be charged for it, okay, because that could be discriminatory. But the illegal deduction issue is very costly.
They
when it
do
comes-
sign something that says they agree to it.
But you can't have a
Every
blanket
injury.
policy, that's the
Yeah.
thing. You can't say, I agree that I'm going to have this amount taken out forever. It has to be per pay period with an exact dollar amount that's going to be deducted from that paycheck for that pay period.
And they can actually say, at 1 week, say no to it.
Right.
That's right.
Okay, I just have a question. Do they have an option or is it just mandatory?
They have an option, they can say, I won't eat this food, or, you know, I can't.
And then,
And this would be one of those cases where an employee can agree to it all day long, but it doesn't make it legal. Okay, so the only way for this to be a legal deduction that you wouldn't be penalized for is if it stated clearly how much was going to be taken out, when it was going to be taken out, and the employee agreed to it. So for a specified amount for that particular pay period and what it was for.
Yeah, I can understand that when and how much, but every week, that just seems ridiculous.
Yes.
What about employees that are repaying debt for like other deductions, like medical insurance or dental insurance? Is it okay for me to get a verbal from them and then put it in writing? But every pay period, because I've made arrangements with a couple of my
Great
employees.
question. You can have something, if it's a specified amount, so let's say it's $500 the employee owes you, right? And you say, we're gonna work out a schedule that the employee agrees to take $50 out of each weekly paycheck until the amount of $500 is repaid. As long as you're putting the specified amount, the pay period that's affected, you could have a schedule and the employee could
That's
agree to
what I
it.
have.
Right, that's perfectly acceptable, but what she's suggesting is something that may or may not happen, and they're automatically taking that amount out, and we don't know how much of the amount is being taken out, so the employee is just agreeing to an unspecified amount per pay period. What you're doing is saying each pay period, and you're gonna list each pay period, this amount is going to be taken out, and you have one signature, and that's it. Now understand, if you terminate that employee before they pay that debt, you cannot take anything other than the regular deduction, like in the example I've given you, $50 out of